Hi, welcome to our channel where we share the most intriguing stories. When I came back from a 2-week trip, all I wanted was coffee and silence. Instead, I found a steel warehouse mysteriously built on my land and a forged document saying I'd approved it. That's when I knew. They picked the wrong person to mess with. I'd only been back home for 10 minutes when I realized something was very, very wrong. It was early morning, sometime just after sunrise, and the lake outside my grandfather's old cabin was calm as glass. A gentle fog still rolled across the water, like it always did in June, that peaceful, untouched quiet that had made me fall in love with the place all over again when I moved in permanently 6 years ago. I'd just returned from a 2-week job in Atlanta, a freelance audit for a real estate firm trying to write off losses that didn't quite exist. And after too many nights in hotels and far too much artificial lighting, all I wanted was my porch, my coffee, and some goddamn silence. Instead, I got metal. 15 feet from my porch, just before the start of the tree line that leads down to the water, there stood a brand new prefab steel building, some kind of warehouse or storage facility, maybe 20 feet long, with corrugated walls, commercial-grade lock on the door, and what looked like a small window-mounted AC unit already buzzing quietly. The kind of structure that screamed municipal utility project, or maybe some pissed-off survivalist with too much money, but it sure as hell wasn't mine. I put my mug down, walked toward the thing, and as I got closer, I saw the gravel path leading up to it. New, freshly laid. A small ramp of poured concrete was drying along one edge of the building. There were still tracks in the dirt from where heavy machinery had come through, tire impressions deeper than my hiking boots. Someone had brought in construction equipment while I was gone, laid a foundation, and built a goddamn structure on my land. The weirdest part? There were white wooden stakes driven into the ground every few feet, marking a perimeter, but no flags, no surveyor ID tags, no posted permits. Just cheap stakes and faint spray paint lines that curved off into the trees. I stood there for a full minute, staring, waiting for my brain to catch up. This wasn't a prank. This wasn't some county screw-up. And it wasn't a neighbor's shed that accidentally wandered too far off-grid. I pulled out my phone and opened my property map. I had it saved for reasons just like this. It took less than 10 seconds to confirm it. The building sat squarely on my land. And not just barely over the line, we were talking deep into my lot. Close enough that if it exploded, I'd lose the kitchen wall. I called the sheriff's office. They said they'd send someone out. No rush. While I waited, I drove into town and paid a visit to the county land records office. The clerk behind the counter was a woman named Charla, who'd known my grandfather back when he was still walking. She smiled when she saw me, then frowned when I showed her the photo of the building. "That's not supposed to be there," she said almost immediately. "You said this is on your lot?" I handed her the coordinates. She clicked through a few screens and pulled up a zoning overlay. "Well, this is odd," she muttered, squinting. "It looks like Crystal Shore Estates filed a use declaration 3 days ago for temporary seasonal equipment storage. Here." She pointed to a small, blue highlighted box that overlapped with my southern edge. I leaned in. The blue box was clearly on my land. "What the hell is Crystal Shore Estates?" I asked, already feeling my stomach drop. She gave me a look. "That HOA, just north of you, up the ridge. Fancy homes, matching roofs, community dock. You're not part of them?" "No," I said sharply. "My lot predates the development. It's grandfathered out. I'm not in any HOA. Never have been." "Then this," she tapped the screen again, "is going to be a problem." By the time I got back, the sheriff's deputy had already come and gone, left a card on my door. I called him back, and when he showed up that afternoon, I walked him out to the site. His name was Laramie, mid-30s, polite, more patient than I expected. But when I laid out the situation, strange building, false registration, HOA trying to claim a chunk of my land, he gave me the kind of look mechanics give when they find a bird's nest in your engine block. "Thing is," he said, chewing his cheek, "they told us it's a disputed boundary, pending clarification. So, unless you've got a court ruling or something with a raised seal, we're technically supposed to treat this as a civil matter. So someone can just build a structure on my land, say, oops, and you walk away." He shrugged helplessly. "Not saying it's right, just how they told us to handle it for now." I could feel the heat rising behind my ears, not from the sun. "This is not a boundary dispute," I snapped. "This is trespassing, land theft, maybe even fraud. "I'm not disagreeing with you, sir," he said, "but my hands are tied. You want this taken down? You're going to need paperwork and a court order." He paused, then added, "But, you should know. Crystal Shore's president called our office yesterday, said there might be misunderstandings with a neighbor down by the lake. Gave your name." Of course she did. I stood in the dirt, staring at the gleaming box of galvanized steel humming softly on my land, and a cold clarity settled in. This wasn't some mistake. This was intentional. They knew I was gone. They knew my house sat apart from the HOA. They'd built this thing here on purpose. They thought I wouldn't fight back. They thought wrong. The next morning, right as I was finishing up documenting the warehouse from every imaginable angle, GPS coordinates, drone footage, thermal scans, even a 3D scan from my LiDAR-equipped phone, I saw a white BMW SUV winding down the private gravel road that led to my house. The kind of car you see parked diagonally across two spaces at Whole Foods. Out stepped a woman in a salmon-colored blouse, pressed white pants, and enough perfume to punch a hole in the ozone. She didn't introduce herself. She didn't even knock. She just walked right up my front steps like she owned the place. "Mr. Taylor," she called out, though she clearly already knew. "Can I help you?" "I'm Karen Milbrook," she said, flashing a smile that didn't quite make it to her eyes. "President of the Crystal Shore Estates Homeowners Association." I wanted to clarify a few things before they got blown out of proportion. Behind her, two men in charcoal suits stood quietly. One held a slim leather folder. The other held nothing, which somehow made him more unsettling. Karen gestured airily toward the gleaming warehouse behind her, like she was pointing out a new pergola she'd just had installed. "This structure is temporary. Summer only. We had it installed for maintenance storage, lawn care equipment, boating tools, flotation barriers, that sort of thing. The placement was determined by our contractor based on available terrain." "On my land," I said flatly. She paused, still smiling. "We believe the boundary lines are a bit ambiguous. The 1996 county overlay was never formally corrected after the development expanded downhill. But this is just a seasonal thing, a convenience. We'll be out by September." I didn't respond. I just stared. Karen's smile tightened. "It's also saving the association nearly $12,000 annually in land use tax. That's money that goes directly into neighborhood improvements, safety, landscaping, community events. Surely you understand. And what part of that makes it okay to build a structure on land that doesn't belong to you?" The man with the folder stepped forward and offered it. Inside was a single-page memorandum of understanding, allegedly signed by me, granting Crystal Shore temporary non-exclusive rights to store equipment on a parcel of my property. The signature at the bottom looked like someone had tried to forge it using only a photograph and a Sharpie held with their non-dominant hand. I almost laughed. "Almost. This is fake," I said, holding the page up to the light. "And if you've submitted this to the county as part of a permit request, congratulations. You've just stepped into criminal territory." Karen didn't flinch. "We had verbal authorization from the prior owner of your parcel. There may have been some legacy understandings that carried forward." I leaned in. The prior owner was my grandfather, and he died in 2009. The only thing he ever gave your HOA was the finger. Her eyes narrowed for just a second. The man without the folder shifted his weight, as if ready to step in should things get less friendly. Karen composed herself. "Look, we're reasonable people. We assumed, given the property's proximity and the fact that it's largely unutilized, that a temporary use agreement would be mutually beneficial. If there was a misunderstanding, we can address it through mediation. Or," I said, "you can take your tin box off my lawn before I file a criminal complaint and a civil suit that buries you in so many restraining orders you'll need a map just to walk your dog." She blinked once, then smiled again, that tight, Botox-friendly country club grin. "I understand emotions are high," she said, "but let me be clear, we have legal counsel. And we've been advised that given the lack of a definitive survey post-development, any encroachment claims would be difficult to enforce without significant precedent." "Good thing I collect precedents," I muttered. Karen took that as her cue to wrap up. She motioned for the suits to follow and turned back toward her SUV. Before getting in, she paused and called out, "We'd prefer to resolve this amicably. But if you escalate, well, the association does have deeper pockets." Then she drove off. I stood on the porch for a while, watching the dust settle. They thought I'd fold. that I'd be intimidated by two guys in men's warehouse suits and a woman whose idea of diplomacy involved $12,000 of unpaid taxes and a forged signature. I wasn't angry, not yet, but I was awake now, and I remembered exactly how these kinds of games were played. I've been called a lot of things in my life: stubborn, cynical, emotionally unavailable, but one thing no one's ever accused me of is being sloppy with paperwork, especially when it comes to land. By that afternoon, I had a plan. The first thing I did was dust off the old manila folder labeled Property Lake Cabin Legacy Docs that I'd kept locked in a fireproof cabinet since I moved in. Inside was every survey, deed, plat map, and notarized document dating back to 1953. My grandfather had kept everything. He was the kind of man who labeled extension cords and wrote his name on duct tape rolls. The HOA never stood a chance. The original deed from 1953, issued before Crystal Shore Estates even existed, showed the full lot boundaries in no uncertain terms. Over the decades, there had been updates in 1971, 1995, 2009. But the borders never changed. My parcel sat independently from anything Crystal Shore built afterward. I even had a letter from a county commissioner from 2012 confirming that my property was not and could not be governed by any HOA due to its grandfathered status and full independence under local zoning law. But it wasn't just about proving ownership. I knew how these things played out in court. Anyone can wave a plat map around. What I needed was irrefutable, modern, objective data. So I launched the drone. It was a Mavic Pro I'd been using for side projects, outfitted with a 4K camera and thermal sensor. Overkill for filming a steel box, but poetic justice always deserved high resolution. I flew 3 full perimeter passes around the structure, the gravel road, and the boundary markers they'd driven into the soil. Then I took the raw data and fed it into a mapping software suite that overlaid my GPS-corrected survey from last year with the drone imagery. The result? A gorgeous 3D topographical model with the warehouse sitting a full 24 feet inside my boundary line. Not disputed, not ambiguous, just stolen. I reached out to a contact, a former zoning engineer named Hal Warner, who I'd met on a previous audit back when I still worked IRS cases. Hal had worked for the town's development office until 2018, when he resigned after blowing the whistle on some under-the-table deals between Crystal Shore and a contractor who'd falsified drainage compliance records. That contractor was later fined. The HOA board, led by none other than Karen Milbrook, walked away clean. Hal remembered everything. When I told him what they'd built, where they'd built it, and that they were now trying to pass it off as a tax-saving measure, he let out a long whistle and said, "Jesus, they're still at it." He agreed to draft a formal statement, notarized, confirming that back in his tenure, he'd flagged Crystal Shore for manipulating property line declarations to push maintenance costs onto adjacent lots. They had a history. Meanwhile, I called the State Department of Environmental Quality and requested an emergency inspection. Because that warehouse, it wasn't just on my land, it was within 50 feet of the lake's protected shoreline, which meant Karen's cute little tax shelter might also be violating about 6 different environmental statutes. And if that didn't get the state's attention, I knew what would. I filled out a report to the North Carolina Real Estate Commission, flagging potential fraudulent declarations on tax records filed by the HOA. I attached my drone data, the fake memorandum Karen tried to pass off as real, and a note that read, "I worked in tax enforcement for 15 years. This is not amateur hour. Look deeper." By the end of the week, I had a 3-inch thick binder of compiled documentation, photos, video, GPS overlays, historical surveys, and expert testimony. I scanned it all into a secure digital folder, printed 5 copies, and stored 2 of them off-site, because people like Karen don't play fair when they feel a corner coming. She'd made the mistake of thinking I was just a hermit with no fight left in him. But I hadn't been this focused since I helped take down a fake land trust in Tallahassee that had defrauded 400 retirees. And that was before coffee. Now I had a direct line to the state, an ex-zoning officer ready to testify, GPS-verified maps, and more documentation than most murder cases. I wasn't just going to take that warehouse down. I was going to burn her entire scam to the foundation. It started with a soft clatter at 3:26 in the morning. I sleep light. Habit from too many years living alone and working cases where people weren't exactly thrilled to be audited. When I heard the distinct crunch of gravel and the low hum of a diesel engine cutting out, I didn't reach for the light. I reached for the thermal monitor. One of the best decisions I'd made in the past week was installing 3 motion-activated trail cams with night vision and infrared on the trees surrounding the warehouse. I mounted them high enough to be missed, masked the casings with bark wrap, and synced the feeds to a secure cloud backup, just in case. On the monitor screen, I watched 2 men, hooded, gloved, moving fast, exit a flatbed truck and begin quietly unloading tools, crowbars, bolt cutters. They weren't there to fix anything. They were there to dismantle the structure. I didn't even need to call the cops. I just hit record. They worked quickly, starting with the back wall, prying loose paneling and dragging what looked like industrial equipment back toward the truck. They didn't touch the front, probably didn't want to move the lock, but they were clearly trying to erase evidence. My guess, they knew the environmental agency was about to show up. By the time they finished and drove off, I had 3 angles of footage, including one with a clear shot of a license plate. The truck was registered to a landscaping firm, one that had been listed in Crystal Shore's last 2 HOA budget reports. Karen was cleaning house. 2 days later, I received a notice. Crystal Shore Estates was filing a civil harassment claim against me. Apparently, according to their attorney, my aggressive and threatening behavior, i.e., sending legal complaints to the state, the county, and the press, was impeding the operational functions of the HOA and creating an environment of hostility. I laughed so hard I almost fell off my deck chair, but it got better. Included with the claim was a list of witnesses, 5 HOA members who allegedly recalled that I had previously permitted temporary communal use of the disputed land in years past, that I'd offered it informally for equipment staging and expressed no concern until recently. None of that was true, not 1 second of it. But it didn't matter. The game was in motion now. Karen was trying to rewrite history with manufactured consent. I was alone, technically. No one else lived year-round within shouting distance of my cabin. She was betting that public narrative and plausible deniability would shield her from consequences. She was wrong. Because while she was busy writing fantasy novels for the court, I was finishing a deep audit of HOA's financials, including a series of recent payments made to consulting firms and contractors. One payment in particular stood out: $42,000 transferred to East Pine Services, LLC, a company registered just 2 months ago to an address that turned out to be an empty lot. Digging deeper, I found East Pine's registered agent, Melissa G. Milbrook, Karen's niece, a graphic designer by trade with no construction or logistics experience. East Pine was a shell company, and the payout? It was made 2 days before the warehouse was built, listed as pre-construction site planning and document processing. That was enough for me to file a criminal complaint for misappropriation of HOA funds, fraudulent contracting, and falsification of HOA financial reports. I attached every relevant page: the East Pine corporate registry, the contract ledger, and the payment timeline. While I was at it, I also filed a formal complaint with the County Contractor Licensing Board. Whoever built that warehouse hadn't pulled a single permit. The gravel road violated runoff regulations. The site lacked a sediment barrier. The entire thing was a walking environmental violation wrapped in a tax scam. I emailed the video footage to the deputy sheriff and copied the district attorney's office. No response. Then I got a voicemail from the sheriff's department. Not the usual deputy. This time it was Captain Ray Hollis, the guy who hadn't set foot on my property in over a decade. His tone was clipped, formal, and icy. "Mr. Taylor, this is Captain Hollis. I'd advise you to refrain from engaging in direct surveillance of private individuals. There are questions about the legality of your footage. If you have concerns, take it to court, but leave enforcement to us." That's when it hit me. Karen wasn't just pulling strings in the HOA. She was reaching into the sheriff's office, too. There was no way in hell that voicemail came from a casual inquiry. She'd made calls, cashed favors, maybe more. Good. That meant I was over the target. And the flack was just beginning. By the following week, the case had gained momentum, but not in the direction I expected. The county assigned a hearing date for my civil suit, a preliminary motion for injunctive relief, plus an official request to remove the structure pending outcome. I was ready. I had 5 binders of evidence, 3 expert testimonies lined up, environmental violation reports, and a smoking gun in the form of financial fraud. Then I saw the name of the presiding judge, Margaret O'Connell. I knew that name. Not personally, but in that way, you know people by reputation when you've worked long enough around local politics and tax filings. She served on the same community engagement board as Karen for over 5 years. Their names appeared on dozens of press releases together, charity auctions, HOA beautification events, and even a short-lived campaign to restore the lakeside aesthetic harmony. I tried filing a motion for recusal due to conflict of interest. It was denied. Insufficient basis to question impartiality. Apparently, having lunch together twice a month didn't count. Still, I held out hope. Evidence was evidence. Paper trails don't care about Pilates buddies. But I should have known something was off when my geotechnical surveyor bailed. He'd been rock solid at first, eager, responsive, even excited to help. Then, 2 days before the hearing, he emailed a bland notice. Due to internal review, we're unable to participate at this time. No explanation, no refund, no callback. That same day, the private environmental inspector I'd contracted, the one who flagged the shoreline violation, told me he was being pressured by his supervisor not to submit his report. That's when I called in a favor from a guy named Eli Temple, an old friend from my IRS days, who now ran compliance for a regional utility firm. I asked if he could discreetly check any recent activity involving Crystal Shore Estates and known vendors. The next morning, I had my answer. A company called Heritage Groundsworks LLC, the same firm listed in HOA meeting notes as the landscaping maintenance provider, had received 2 large wire transfers from the HOA General Fund, both labeled off-contract consultation. One transfer was for $12,000 dated the same day my geotechnical guy dropped out. They weren't just using HOA money to build an illegal warehouse. They were using it to sabotage my witnesses. I submitted the findings as a supplemental filing, accusing Crystal Shore of misuse of communal funds, witness tampering, and obstruction of a civil proceeding. A day later, I was served again, this time with a cease and desist letter accusing me of defamation against the HOA. They demanded I retract my claims, cease communications with third-party contractors associated with the association, and issue a public apology to correct the reputational damage caused. I framed the letter and hung it in my bathroom. Behind the scenes, cracks were beginning to show. An anonymous email arrived through my website's contact form, a scanned letter from 2 HOA board members who refused to reveal their names but stated that President Millbrook has repeatedly acted without board approval and that they were concerned about legal exposure. One line stood out. We believe Ms. Millbrook authorized unrecorded expenditures and selectively withheld meeting minutes to push through projects with personal benefit. I sent it straight to my attorney, who smiled and said, "Now we're cooking with kerosene." At the preliminary hearing, Judge O'Connell looked me over like I was a disruptive neighbor who played jazz too loud on weekends. My attorney, Monica, laid out our position calmly. Trespass, fraudulent misrepresentation, forged documentation, and improper use of HOA funds. She submitted the binders with a precision that reminded me why I'd hired her in the first place. Then Karen's legal team, a pair of smug pricks in $1,000 suits, stood and tried to argue that the land had been historically informally shared between the HOA and my family, and that the structure's location was the result of cartographic confusion. I almost laughed. Then the judge barred my drone footage, citing chain of custody uncertainty. That's when I realized the whole thing was rigged, or at least slanted. Didn't matter, because I had a backup plan, one that didn't rely on county favors. I'd filed a parallel complaint with the North Carolina Office of State Auditor, citing the HOA's tax irregularities, shell company contracts, and suspicious budget reallocations. They had jurisdiction and a reputation for being less social. And if the state picked it up, there wouldn't be enough country club brunches in the world to save Karen Millbrook from the hole she'd dug. They wanted to play this game sideways. I could go sideways. Hell, I'd invented sideways. I didn't think Judge O'Connell would flinch. I was wrong. 3 days after the preliminary hearing, just as we were preparing a motion to appeal her drone footage ruling, my attorney Monica got a notification. The judge had filed a voluntary recusal from the case. The reason? Recent developments indicating possible conflict of interest. Translation: someone upstairs told her this stank, or maybe the state audit complaint had landed harder than expected. Whatever the cause, our case was reassigned, this time to Judge Ansel Merrick, a retired federal circuit judge now moonlighting in district court, known for his bulldog temperament and zero tolerance for procedural games. Not a brunch guy. Not someone Karen could charm. The tone shifted immediately. Karen's legal team filed a request to delay proceedings. Denied. They filed a motion to dismiss the environmental complaint as not material to the civil action. Also denied. Then came discovery, and with it, the unraveling. First came the bombshell from inside. It's a HOA's treasurer, a soft-spoken CPA named Leonard Chris, who'd apparently grown weary of Karen's presidential prerogatives, submitted an affidavit stating that several board members had been routinely excluded from financial approvals over the past year, including him. He attached emails where Karen directed HOA staff to approve disbursements under urgent authority and postpone vote records until we're in the clear. He even included internal memos where she referred to East Pine Services, her niece's shell company, as our off-books solution. That one phrase might have just bought me the win. But it didn't stop there. Monica subpoenaed East Pine's full banking records. We traced not only the original $42,000 transfer, but several smaller ones totaling over $78,000, all paid over 4 months, all from Crystal Shore's General Operations Fund. None of these payments were disclosed in member reports. None were authorized by vote, and at least one was used to pay the same contractor who'd been caught dismantling the warehouse on my trail cam footage. We were no longer talking about a zoning dispute. We were looking at a full-scale financial fraud orchestrated from inside an HOA, using its residents' money on land they didn't even own. When Monica submitted this updated dossier, including Leonard's affidavit, the bank records, the shell company registration, the environmental violation report, and my own photographic evidence, Judge Merrick didn't say much. He just leaned back in his chair, steepled his fingers, and said, "I see no ambiguity in these facts, and I see no reason to delay this any further." Karen, sitting 2 rows back, had finally stopped smiling. And just when I thought we'd hit the high point, the real twist landed. A sealed envelope arrived at Monica's office from an anonymous HOA member. Inside was a dual-entry ledger, 2 sets of books. One set was the official HOA budget, neat, audited, matching public filings. The other was a private version, hand-notated and riddled with corrections, showing temporary construction, listed under Taylor Parcel, unzoned, with a scribbled note next to it, verbal okay, no paper trail, liability unclear, keep off. Minutes. Whoever wrote that knew damn well what they were doing. We ran handwriting analysis. The note matched Karen's personal HOA notes from an earlier public newsletter. Sloppy K, overly loopy Y, and a weird slant on the T's, same hand. Karen had kept shadow budgets to hide unauthorized spending, building on land she didn't control, all to reduce her HOA's tax obligations and consolidate power. And now it was all admissible. Judge Merrick authorized a full evidentiary hearing. He even fast-tracked it, but I wasn't done. I forwarded the updated evidence, especially the dual ledger, to the district attorney's office, the North Carolina State Ethics Commission, and the Office of HOA Oversight, which had been quietly following the case since the environmental violation hit state press. Karen had tried to rule her HOA like a fiefdom. She was about to find out what happens when the peasants get access to public records and subpoenas. It was a warm Thursday when we finally walked into the courtroom for the evidentiary hearing. A little humid, sky full of Carolina haze, the kind of morning that made you feel like something was about to break, weather or otherwise. Inside, the tension was thick. HOA members packed the gallery, whispering in clumps. Some looked angry. Some just looked tired. Karen sat at the front, blazer sharp, lipstick sharper, her posture military straight. Her lawyer didn't smile this time. Judge Merrick didn't waste time. He opened the hearing with a brief summary. This was no longer a routine civil boundary case. It involved trespass, unauthorized construction, financial misconduct, forgery, and environmental violations, with overlapping jurisdiction between the county, the state, and the HOA's own charter. First up was the expert witness Monica had wrangled from the state auditor's office, a stone-faced man named Darnell Wu, who walked the court through financial inconsistencies in the HOA books with surgical clarity. He presented slides showing mismatched ledger entries, East Pine Shell activity, and payments that went missing from HOA reports but showed up in vendor bank records. Then came Leonard Criss, the treasurer. He took the stand and, under oath, confirmed that Karen had overridden financial procedures, suppressed vote records, and used HOA funds without approval for personal initiatives, including a warehouse facility on disputed land. Karen's face didn't move, but her fingers started tapping silently on the table. A steady rhythm, tick, 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 like a countdown. Then it was my turn. I walked the court through my drone data, the boundary surveys going back 70 years, the GIS overlays, the forged memorandum, the nighttime dismantling attempt caught on infrared video, and the environmental complaint tied directly to the unauthorized gravel path within the protected lakeside buffer zone. Monica handled the final punch. She submitted the handwritten dual ledger, laid out the handwriting comparison, and concluded with the scanned emails where Karen explicitly authorized payouts to East Pine with the phrase, "Let's keep this off the books for now. I'll clean it up later." The silence in the courtroom was deafening. Karen's lawyer objected to the ledger's admissibility. Denied. He claimed the audit expert had a conflict of interest. Overruled. He tried to pivot to community benefit. Merrick cut him off. In the final stretch, Merrick read from the bench. The evidence before this court demonstrates not only a deliberate encroachment upon private property, but a concerted attempt to obscure financial activities, falsify documentation, and exploit legal gray zones for institutional gain. This was not negligence. This was strategy, executed with intent and concealment. Then he laid down the ruling. The warehouse must be removed at Crystal Shore Estates' expense within 30 days. A fine of $312,000 was awarded in my favor for restoration, legal fees, compensatory damages, and civil penalties. The structure and surrounding area were to be inspected by state environmental authorities, with all violations forwarded for prosecution. The HOA was ordered to conduct a full internal audit, supervised by a third-party trustee. And then came the big one. Judge Merrick announced he was referring the matter to the district attorney's office for criminal prosecution. Before the gavel even hit the wood, a pair of deputies walked in and approached Karen. She didn't flinch when they asked her to stand. She did, however, look at me. For the first time, her eyes had something behind them. Not rage, not arrogance, just disbelief. She was arrested right there, charged with tax fraud, falsifying public documents, misappropriation of HOA funds, criminal trespass, and obstruction of justice. The courtroom exploded. HOA members gasped. Some looked horrified. One woman whispered, "Finally." Her lawyer tried to object to the cuffs. She's a community leader. But the judge had already stood up and left. I followed them out, watched from the sidewalk as Karen was placed into the cruiser. A few HOA board members stood nearby, already on the phone. I knew that tone. Not denial, not defense. Damage control. Later that day, I got confirmation that the HOA had voted to immediately suspend Karen as president, pending the outcome of the criminal proceedings. Her own house, purchased under the HOA umbrella, was placed in lien review to cover potential debts. The empire was cracking, and all I'd done was come home to a metal box where it didn't belong. A week after the hearing, the warehouse was gone. They didn't even try to take it apart gently this time. A demolition crew, hired by an emergency vote from the HOA, ripped it down in less than 6 hours. The gravel road was bulldozed, the debris hauled off, and what was left was a patch of torn-up earth, still scarred, but mine again. I planted pine saplings along the edge where the steel box had stood, not for privacy, for memory. Something to remind anyone walking by that land has weight and consequences. Right by the path, I mounted a small wooden sign. Nothing fancy, just engraved letters. Tax savings minus $12,000. Total cost $312,000. Never build on land that isn't yours. Within a month, Karen was indicted on 5 felony counts. Her bail conditions included a ban from participating in any organized residential governance. The HOA board began releasing minutes again, and each one now opened with a public disclaimer. This meeting is held under financial supervision due to pending legal matters. But the impact didn't stop there. Local media picked up the story. First, as a human interest headline, Hermit versus HOA, the fight over a lakeside warehouse. Then as something bigger. I started getting emails, dozens. people asking for help, for advice, or just to say thank you. Apparently, my little war had touched a nerve. Eventually, a small legal podcast invited me on, then a news station, then a university panel on property rights. Now I consult part-time, not for money, but to help folks who've been steamrolled by the same kind of overreaching bureaucratic smugness I'd spent my career dismantling. Funny, I left the IRS to find peace. Turns out I just needed the right war.